My Lords, my Lady, the first of the 5 points that I said I would touch on, and I will do so briefly, was the suggested point of principle in the appeal, which I should address, albeit that it appears very late in the skeleton at paragraph 63 and was only slightly developed this morning. But, of course, if it could be shown that the judge had addressed himself to fundamentally the wrong test, then that would be something that could be said to justify reconsideration by this court. But in my submission, that is not a tenable argument. It's clear that a sequencing decision of this kind is a decision for the court by reference to the overriding objective and the interests of justice, and not some other principle or presumption. It is, in my submission, a classic exercise of a number of the case management powers that you see in CPR 3, and just one instance of a type of decision that the court comes across in all sorts of other contexts. For example, the decision to stay something pending an appeal, or to have a split trial, or any number of other alternative situations where the court decides to defer the evidence and determination of an issue. I see my Lords there have opened, I think, probably CPR 3.1, which is on page 73 of the White Book. And there are any number of powers in here, including, for example, B, to adjourn or bring forward a hearing, F, to direct that any part of any proceedings be dealt with separately, G, to stay the whole or part of any proceedings, J, to direct a separate trial of any issue, or K, to decide the order in which issues are to be tried. And there are probably other powers in there as well, which you could say are exercised or potentially exercised by a decision of this type. And in my submission, the Athena case, which was cited by my learned friend and in the skeleton, which is at page 221 of the authorities bundle, does not assist any such submission that there was an error in principle here. And that's for two main reasons. First of all, it does not lay down any presumption as a general matter. The dicta cited are not the test, as my Lord Justice Mayles made clear in that case. And second, Athena, Reichhold, etc. are fundamentally an entirely different type of case. And one can get that if one turns forward to page 233 of the bundle. And you see at the bottom there, in particular, paragraph 48 identifies clearly what was, I think, the central point of that judgment, which is that there is no express requirement, it's a wide discretion, and the test is simply what's required by the interests of justice in the circumstances of the particular case. And paragraph 49 goes on then to talk about the wide variety of circumstances in which a power to stay or defer might be exercised. And of course, the second point that is made at the end of paragraph 49 there is that the types of cases in which the court has said that it may require exceptional circumstances or a compelling reason to defer determination are generally, as it's described there, to allow actions in other jurisdictions to proceed, the usual assumption being that the outcome of the foreign proceedings will or may render the proceedings here unnecessary. So that is obviously a very different type of case, because in those cases, the English court may be, as a matter of practicality, wholly or largely giving up jurisdiction over the issues for determination in an arbitration or by a foreign court. And in my submission, the considerations applicable in that type of case, which is what Athena is really dealing with, are radically different from the considerations applicable in this case, because there's no question of the issues that the FRN wants to have determined not being determined unless they are rendered moot by something different namely the fact that there's nothing to pay or it's paid by P&ID. Now, my learned friend also cited two cases specifically to do with third-party costs orders, Magomedov and Capital Maestro. The short point on those two is that they are no more than examples of the existence of an open-ended case management discretion being applied in very different circumstances to the present case. So Magomedov is at tab 15 and it's page 337. And if one looks at paragraphs 14 and 15 in terms of what was sought in that application, particularly paragraph 15, one sees that all the judge was dealing with at that case was an application to identify the funders so that they could consider seeking third-party costs orders and possibly joining them. And of course, that information about the funder is information that was sought and given in this case a long time ago. So this case, the Magomedov case, doesn't tell you anything about how the court might have dealt, even in the circumstances of that litigation, with an actual application for a third-party costs order, had one been made. At that stage, the winning parties had not even decided whether they would want to or be in a position to join the funder at all. Capital Maestro is similar but with one different characteristic. So this is at tab 14 and it's page 329, paragraph 6. And you see there from paragraph 6 that again the question was an application for disclosure and information about who the funders were. So it was known that Mr. Sherwin was a funder, but disclosure was sought about other people. And then it was accepted, at least, that there should not then be any further directions hearing on that until the Court of Appeal had dealt with a substantive appeal in the proceedings. But again, there's no consideration at this stage as to the sequencing of an actual application. The other point that I wanted to make from Capital Maestro was to note that that appears to have been a case, and I get this from the combination of paragraph 2, 1 and paragraph 40, that appears to be a case where it was agreed that the detailed assessment should be stayed. So it certainly doesn't appear to have been a case in which the successful party was proposing to pursue a parallel track as the FRN does here, which is to say, I'm going ahead with the detailed assessment and I am also pursuing a third-party costs order in parallel. So that was really all I was intending to say on the first of 5 points, the point of principle. The second point is the fact that the third-party application may simply be moot if neither of the contingencies come in. That is to say, either it's found that nothing is owing, or whatever is found to be owing, or some agreed sum is paid. And obviously I need not repeat those points which are fundamental to the judge's decision. What I do need to do is to make a handful of additional, slightly more detailed observations about why, in my submission, the judge was correct to have regard to those contingencies as real possibilities. In relation to the sum which might be owing, the first and important point to note is that this is a standard basis assessment. The FRN has hinted, certainly in its skeleton, that it might be assisted by various conduct points, but the judge did not conclude that. The FRN applied for indemnity costs on conduct grounds and was refused that. And the judge in his trial judgment, for example, made the point that P&ID had cooperated and indeed had properly provided disclosure of adverse documents which had helped the FRN prove its substantive case. And there's obviously a difference here between the original arbitration, which concluded in January 2017, before VR had any involvement, and the subsequent proceedings before Mr Justice Knowles, which were commenced in 2018. And VR's position, of course, is that it was a victim of the very same scam as the FRN, in terms of there being an award which was improperly procured. So this would be a standard basis assessment, and that is particularly important, or will be in due course particularly important, in considering whether sums that have been spent that may be said to be justified but represent an expensive choice of counsel or solicitors, or to spend time on side points, whether those would prove to be recoverable or not. The second point, which you already have the basic point, is that an interim payment has already been made and ordered of a very substantial sum, almost 50%. Now, every lawyer probably has a different rule of thumb as to what they might expect to see recovered on a standard basis assessment as a percentage, and I think Mr Ford put forward a slightly bigger thumb this morning than I would put forward. The one submission that I would make is that by observation of reasonably big ticket commercial litigation in recent years, even in the ordinary course, percentage recoveries may be thought to be lower than they perhaps once were, particularly as a result of the court's adherence to guideline rates, which are less than a lot of top firms charge, and certainly less than Mishcon were charging in this case. The third point, and this is really, I think, the key, is that based on what the court has seen and based on what the trial judge had seen, there was every reason to think that additional reductions were likely to be made. I start with the proposition that if one looked in the abstract at the trial judgments in this case and without seeing the bill, and asked whether one might expect the FRN to recover more than 20 million of costs for a case of that scale, I would speculate that the answer to that would probably be no. The central point, though, is that the judge was much better placed than any of us to form that view, for two reasons. First of all, because he had been the case managing judge throughout the proceedings, and secondly, because that was essentially very similar to the exercise that he had done when setting the interim payment at 20 million in the first place. So in my submission, there can't be any sensible reason for Mr Ford to be able to argue either that the judge was wrong in his assessment, that it might be that nothing more was recovered, or that the judge somehow didn't have that in mind, I don't know quite what the submission would be, that he hadn't thought about what the level of costs was, or had forgotten that his own view would be that actually they were likely to get significantly more than 20 million. That really can't work as a submission in circumstances where the judge taking this decision was the trial judge and the judge who set the interim payment. In terms of the amounts, what I am obviously not going to do is rehearse any of the detail that is to be ventilated, hopefully in abbreviated form, in the detailed assessment proceedings. But there are simply 3 points that I wish to highlight that are taken in those proceedings. The first is that the court's eye was drawn to the brief fee for leading counsel of 10 million. And I say,
I think
no.
It was you that drew it to us.
In the skeleton it was. That's true, my lord. But I infer that the eye did follow. And that really is a point that speaks for itself in terms of recoverability on the standard basis. The second point is the solicitor's costs, which total something over 16.8 million. And those include rates which are very significantly over the guideline rate. So, for example, a Band A partner rate of up to 800. For reference, the current guideline rate is 580, but obviously it was lower during the course of these proceedings, and grade C rates of up to 450, when the guideline even now is only 305. So on an assessment down to the guideline rate, which, given the guidance of this court in the Samsung case, I would submit should be at least the assumed starting point, one is looking at immediate reductions just on an hourly rates basis alone of something like perhaps 30% or even more. And so that's something that would have to be taken account of before one even gets to the brass tacks exercise, which I'm clearly not going to attempt, of how much time should have been allowed for any given task, bearing in mind that what's claimed is something like 50,000 hours of solicitor time over the course of the case.
Yes, I can at any rate see the argument that this case might, at least in some respects, justify something in excess of the guideline rates. But no doubt that's a matter for the costs judge.
Well, exactly, and that's the point, my lord. That unless one is forming a firm view as to which way the cost judge is likely to determine that, it isn't really possible to get off the ground a submission that the FRN is likely to recover more than it's already had. And so the third of my 3 points was to note that there's a total of over 10 million of what I would describe as external costs, i.e. costs not of solicitors, not of English solicitors or counsel. And that includes some 1.25 million on media and PR, including Portland Communications. 5 million spent on, as I read it, non-solicitor e-discovery work, and 4 million spent on applications overseas, including in the US and the BVI, the relevance and utility of which is all disputed. So again, it's not my submission that you can assume they will recover none of that, but those are some very obvious, very big ticket items where it seems entirely possible that they will be allowed nothing, or certainly nothing more than the 20 million that they've already got.
Can you tell us, just in general terms, so we get a feel for it, I don't want you to go into detail, but there was reference to preliminary issues in the detailed assessment. What kind of issues are those, and are they the kind of issue which, once determined, ought to crack the case? Or will it, regardless, be necessary to go through the detail in the July and subsequent hearings?
The short answer, I'm afraid, is that I can't tell you that because I haven't seen the formulation of them. And of course, those instructing me don't have conduct of those proceedings because they are at present between the FRN and PNID. So at the moment, I can't tell you anything about that. I could take instructions on it if that's thought to be potentially helpful.
Well, it's probably not critical, but it would, perhaps Mr Ford knows and can tell us later.
Yes, that may be a possibility. So, taken together in my submission, all of that explains why the judge explicitly mentions more than once the possibility that they may get nothing more, or that anything more they might get, the size is unknown. There is then the second contingency, which is even if the court finds that there is more to be paid, or there is an agreement in the detailed assessment as to what the figure should be, whether that sum will be paid voluntarily by PNID, or if when the sum is known there will be some compromise of everything, including the third-party applications. On this point, which was not, I stress, the main point which the judge relied on, he was much more interested in the first contingency, I should be clear about what I am and am not saying. Mr Ford seemed to suggest that this was a relevant factor only if there could be something approaching effective certainty of voluntary payment by PNID. So at various points he put the question as whether there would be no utility in going ahead with the third-party costs application as a result of that. I would say respectfully that's not the right way of looking at it. The actual question is whether the judge was entitled to put some weight on the fact that there is at least some real prospect that a sum might be paid voluntarily.
I mean, just to say
yes.
that means that your clients will fund it, doesn't it? There's no way it will be paid voluntarily from any other source, so far as the evidence before us is concerned.
I think as far as we know, that's right. Mr. Ford mentioned, for example, the possibility of claims against directors or third parties or whatever. So I suppose that can't be ruled out. But you're absolutely right that as far as the evidence before you is, there is no evidence of P&ID currently having its own funds to make that sort of payment. But, of course, against that, there was no such evidence at the prior stages either. And the fact is that the 20 million ordered to date has been paid.
But you had to pay that, didn't you, in order to carry on with things? You'd been disbarred, or debarred rather than disbarred.
Well, P&I, one has to be slightly careful about who would have been debarred from what in that situation. Because, as I understand it, the way that would have worked would have been if P&ID had not paid, it would have been debarred from disputing the quantum of the detailed assessment. But, of course, if there is no liability of VR or Mr. Dietz in respect of those sums, then that would be in itself no skin off their noses. And it's...
But if they were debarred for the cost was X, and they did subsequently get a third-party notice, you'd be stuck with the costs already determined, wouldn't you?
Well, I'm not sure about that, my lord, because the position now, as a result of the hearing before Mr. Justice Knowles, is that VR and Mr. Dietz have agreed to be bound by the outcome of that assessment. But it's not obvious to me that the FRN could have proceeded with an assessment against a debarred claimant, P&ID, got a figure of 40 million or whatever they were asking for, and then gone off and said, right, third parties, you're liable for this.
Why ever not?
They'd have to go and get an order, but why not?
Well, because the ordinary principle is that if the court makes an order for costs against a party, that party's entitled to have those costs assessed. So it would
Well, there would then, I suppose, be a question whether the third parties, your clients, were effectively privies to P&ID, which would raise a very similar question, even if not identical, to the question whether they should be liable to a third-party cost order in the first place.
Well, indeed. So it would all come back to the question of whether they really would be liable for this or not. So in my submission, and I don't need to place undue weight on this, but in my submission, the fact that the existing orders have been paid is, as I think the cases indicate, something that the court would be entitled to place some weight on. It is obviously not the main reason. And in my submission, it wasn't the judge's conclusion, and it didn't need to be, that they definitely would be paid. But as part of a wait-and-see approach, it is a legitimate thing to consider.
Well, I'm not sure that's your best point, but anyway, you've made it now.
Well, I'm not sure it's my best point either, my lord, and and as I've tried to stress, it's not a point that I need, but in my submission it is a relevant point and one of many that the judge was entitled to consider in his assessment.
Right.
Coming to the third of my 5 points, which is the judge's regard to the potential scope, complexity and expense of the third-party applications. We traversed this quite extensively this morning, and there is therefore relatively little that I need to add. The fundamental point, of course, is that this is very different from cases like Magomedoff, where all that was being sought in that case at that stage was an order for disclosure of who the funders were. What is contemplated here is a whole satellite procedure involving allegations, joinder, they seek disclosure, and some sort of very substantial hearing determining that. And I did want to highlight a little further the choice that the FRN has made to go against Mr. Dietz as well as VR, which is a complicating factor of its own choosing, I make the point that it, on the face of it, appears to be an entirely unnecessary decision. It's hard to see, given indeed what Mr Ford said this morning, that there's much of a realistic prospect that they would get an order against Mr Dietz personally, but not one against VR the fund. There's no suggestion that VR the fund is impecunious. So one is left thinking that that attempt to join him as well appears to be either tactical and or straightforwardly vindictive. And I make the further point that there doesn't appear, and the case as it's put is very sketchy, there doesn't appear to be any allegation that Mr Dietz did anything outside his capacity as the manager of and an investor in VR. And that, of course, will be relevant because it has an impact on the bar that the FRN would have to clear and the scope of the issues that the court would be determining if it were allowed to allow the third-party proceedings to go ahead in parallel. And there's one authority which I just wanted to highlight on this, which is the Goknur case, which is at tab 11 of the authorities bundle. If one goes to page 212, so this is part of a quite lengthy citation by the deputy judge from a decision of Judge Matthews in the housemaker case. And you see there under the heading company directors at paragraph 11 of the quote, there's a highlighting that the position of company directors is or may be different. And in particular, you see paragraph 15 of the quote, the something more that is classically required to be shown against a company director. For example, that they've not been acting in good faith or for the benefits of the company, or they've conducted the case improperly. So this is the sort of hurdle that the FRN is choosing to erect for itself by proposing to pursue the application that it does. And you see at paragraphs 39 and 40 that the deputy judge in that case endorsed what Judge Matthews had said in the prior case, and also cited Lord Justice Millett in the Metalloy case, making comments to similar effect. So that has two impacts. First of all, it has an impact on the volume of resources, both the courts and the parties, which the judge was choosing to avoid or defer being deployed at this stage to resolve something that might turn out to be pointless. And secondly, I think there is a further point there, which is that sort of inquiry, making allegations of, in effect, bad faith against people, is not a process that the court should be keen to pursue in circumstances where it may turn out to be otiose or academic. And the further point under this heading was that I said I would take you to the disclosure application this morning, so I'd better briefly do that now. This is in the supplemental bundle and it's at page 101. And perhaps the most useful place to be actually is at the draft order, which is page 106. So this all relates to the shareholders arbitration, which is, as described by Mr Ford this morning, an arbitration between Process Holdings on the one hand and Lismore, which is the company associated with Mr Andrew and Mr Cahill personally. in relation to process holdings investment. And you see in paragraph 1 of the order what is sought are various specific documents in the so-called shareholder arbitration. But then at paragraph 1b, the demand is to conduct a reasonable search for and provide inspection of all further documents in their possession and control, either filed by the parties or rendered by the tribunal in the shareholders' arbitration. So on the face of it, that would seem to include all of the evidence, witness statements, certainly exhibited documents. I don't know if it would include disclosed documents that were not filed with the tribunal, but essentially at least the whole of the, whatever the tribunal's equivalent of a court file is in those proceedings. That application, I can tell you now, would be contested. But I make the point that even if it were granted, it would be a substantial and extensive process to produce and analyse everything that is described there. An obvious further point in respect of that is that there would be very probable issues with privilege in a lot of those documents relating to the conduct of the arbitration.
Doesn't say that, does it? B doesn't say relating to the arbitration. It says once you've decided what file means,
Yes.
which clearly refers to disclosure of some sort.
Yes.
Whether it's sending the documents to the other side, or I don't know if you send documents to the LCIA these days. Maybe not. There's no question of any privilege there, is there?
Well, I'm not sure if that's right, because of course these were parties that at the time of the transaction between them and during the conduct of at least the arbitration were friendly parties. Process Holdings thought it was investing in P&ID and that they were presumably cooperating on the enforcement of an award. So one can imagine, for example, that there may well have been documents between them that would not be privileged as between them.
Common interest privilege.
That sort of thing, exactly. But I mean, that's all...
or perhaps arbitral confidentiality, although that doesn't sound very likely, but you never know.
Well, yes, it's very hard to know, I think, where it starts and where it finishes. But those are all questions that would have to be considered on the disclosure application.
But whatever, I see that, but whatever that would be, there will be, as it were, a finite and defined or definable body of documents within which to look. It's not a case of going and searching all the files.
No, it's not a standard disclosure search in quite that sense. That I do accept. But the point is that the volume of material and its nature that will produce is substantial. And then it's apparent, given what I've just shown you from the Goknur case and from the brief allusions made by Mr. Ford this morning, that it's intended to construct a case in particular against Mr. Deeds, that there was some impropriety or bad faith. So that almost inevitably is going to have to be, if it were pursued, set out in some proper form, whether that's points of claim or whether it's a very detailed witness statement. It's certainly something that doesn't yet currently exist. And there would undoubtedly then be evidence in support of that case, evidence in response to it, all before you get to whatever kind of trial or mini-trial or determination you have to have at the end of the process. So it's this, to be pejorative about it, circus, and an unnecessary circus, particularly in relation to Mr. Deeds, that the learned judge was saying, well, hold on, let's wait and see if any of this is ever needed. So moving on to my fourth point of 5, in my submission, the only prejudice caused to the FRN by deferral of the application is a potential delay in any eventual recovery if the multiple contingencies are satisfied, and delay is not a strong point here. That is principally for the usual reason in a situation where issues are deferred, for example, a split trial, and where those issues are about money, which is that in any situation where the potential paying party, to wit here VR, is amply solvent, and where the potential recipient, to wit the FRN, is not impecunious, then any delay in ultimate resolution and payment can always be compensated for in interest. And indeed, if the applicable interest is 8%, then, as was said this morning, that might turn out to be a good investment. The other arguments which are sometimes made in relation to delay and were gently ventilated here about how delay, for example, can prejudice the adjudication of the ultimate application, in my submission are not very strong here. This is not a case that the trial judge is likely to forget, but also, importantly, it's not a case where the basis for the third-party application is principally to do with matters that were already determined at trial. The whole basis on which this appears to be constructed is that it is about the funding and conduct of the litigation behind the scenes, and making new allegations against VR and Mr Deeds that were not made, let alone adjudicated, in the trial. So while it's certainly true to say that Mr Justice Knowles would have the background, and nobody is saying that anyone other than he would be the best person to try it, it's scarcely a case in which it can be said that deferring all this until after the detailed assessment is likely to materially diminish the quality of the ultimate adjudication. And the further point in relation to all of this is that certainly in terms of its conduct in trying to get back or get its costs following the judge's judgment in the trial, and by way of detailed assessment, the FRN has not shown any particular tendency towards expedition. So I made the point this morning that it had taken them some 13 months from the trial judgment to produce the 40-odd million bill of costs which they now rely on. So that has obviously delayed the kick-off of the detailed.
Is there a provision in the rule saying when that should be filed?
I think there is, but I'm afraid I can't point you to it off the top of my head. My point is less about non-compliance with the rules and more about whether they have demonstrated particular urgency in trying to recover this in a world where delay is said to be prejudice.
Yes. No, I was just trying to get some context, that's all, because if the rules expect that you do it in, say, 3 months, then it's a more powerful point that it took them 13 than if the rules expect you do it in 12 months.
Yes, quite. I think those behind me are going to try and confirm that for us. But that is the essence of the point. The other point, which I think the court was aware of and mentioned this morning, was the third-party debt order issue relating to Zhongshan, where there was a period of over a year from March 2024 to April 2025, where the FRN was not being paid, not because of any unwillingness of P&ID to pay them, but because Zhongshan had obtained this order in the BVI, a third-party debt order, and therefore the FRN didn't actually want the money to be put up because it would go out again to Zhongshan. And eventually the FRN resolved its differences with Zhongshan, but again, that took over a year. So none of that is to say that delay is no prejudice. And I made submissions this morning about how the judge had looked quite carefully at how that prejudice might be mitigated. But they are relevant factors as to whether delay is actually a truly significant factor here. And in my submission, it isn't. The fifth and final point was a sort of a sweep-up point to say that the additional points do not carry any real weight. The point about settlement, or this idea that P&ID might have some increased incentive to drag out the detailed assessment, in my submission just doesn't make sense. The actual position is that both third-party liability and detailed assessment are heavily contested. Even if the third-party application were to go ahead now, it's not going to be resolved until long into, or possibly the end of the detailed assessment anyway, in which there has already been a huge amount of ink spilled. And it follows from that that if there is a basis on which the detailed assessment, or indeed the whole thing, could be settled, then it would plainly be in the parties' interests for them to do so. But it's not really apparent why or how the determination of the third party point would assist that in the abstract, if you still don't know whether the number is nothing or if it's 20 million.
Well, not being naive about it. If you don't know whether it's going to be 20 million or 10, and you're exposed to 20 million, and it's then found that you are in fact liable as a funder, you might have more incentive to put your hand in your pocket. That's Mr. Ford's point.
Yes, and that's his bargaining power point.
Yeah.
But in my submission, that's not a legitimate factor for the judge to be considering. The court doesn't regulate these questions by reference to the collateral effect it may have on the parties' respective bargaining power. The judge, I don't think that submission was made quite in those terms to the judge, because they would be rather naked terms. He certainly didn't, I think, consider in his judgment that he should be putting his finger on the scales one way or the other in terms of bargaining power. The relevant factors must be things like use of the courts and the parties' resources. And I would also say...
Well, he can think, can't he, that whatever I do is going to, potentially going to have an impact on the bargaining power of the parties, but it's not my job to favour or disfavour anybody. I've got to do what I think is the best thing for the conduct of the proceedings.
Indeed. And of course his particular emphasis actually was on court resources, although it's clear that there is also an issue about money being spent by the parties unnecessarily. So in my submission, the settlement and bargaining power stuff doesn't really go anywhere. It is also obviously the case, as it is in any commercial claim of this type, that the parties will have advice, including on the questions of third-party liabilities and what's likely and what's not. So if the FRN actually wanted to come to the table and have a discussion, and VR wanted to do the same, there's nothing to stop them doing that.
And I suppose in terms of court resources, although we've debated how many days the hearing is, it's also legitimate to take account of the fact that a hearing requires a judgment, and a judgment takes time to write unless it's a very simple matter.
Well, indeed, and the way in which it looks like this is intended to be put is not a very simple matter. Quite the reverse.
Well, I mean, the point I was making, even if it's a 3-day hearing, that doesn't simply mean 3 days of court time.
Well, absolutely not, but it could mean a lot more court time. The other thing that one, don't mean to encourage it, but one can't rule out is whether there might or might not be other interlocutory skirmishes about all of this. Will they stop at the disclosure they're asking for example?
Yeah, well, the judge was obviously very alive to that.
Yes, quite.
He experienced the litigation.
Yes, quite, and that is, we say, a relevant factor. There is an apparent element of scorched earth in all of this that should be borne in mind, and particularly should be avoided where what the parties might be arguing about is something between 0 and 20 million. It is not any longer an argument about 11 billion or whatever it was. And that's something that the judge clearly had in mind. And in our submission, the FRN's approach doesn't so obviously have that in mind. the final point then was just this point about the participation of the third parties in detailed assessment, which is sort of mentioned in some of the cases. But the answer to that is it's been dealt with here. This was something the judge was very alive to. You saw it on the transcript. It was made clear, and they agreed that the third parties would have to abide by the outcome of any assessment. And of course, there's no reason why they shouldn't do so when P&ID are visibly taking all the points. So in my submission, that in a different world or a different type of case, that might be a reason why you might deal with third party first. But actually in this case, it was an issue the judge identified and solved. And there's no reason to criticise him for that. So those were my 5 points as developed. So subject to, I will turn round, but subject to that, I had nothing else to add. CPR 47.7, I am told.
That's the answer. Remind me what the
Gives
question was.
3 months
Timing.
to
Oh, yes.
start detailed assessment. And I'm told that the FRN applied for an extension for that.
Thank you very much to those behind you. Yes, Mr Ford, anything in reply?
My lord, briefly, probably about 10, maximum 15 minutes worth. First, it was said that effectively it's an irrelevant consideration as to the bargaining power or the positions of the parties. And with respect, one of the considerations in the overriding objective of this course, giving assistance to ADR and matters such as that. And to that end, first of all, the court can rightly recognise that determining a particular issue or an issue of liability up front may assist the case as a whole settling. And likewise, we have provision for things in a different context like early neutral evaluation, where it's recognised that actually a clear steer by the court at an initial stage may lead to consequences in terms of settlement and things like that. And in that context, we do say that the determination and the argument that the determination of the liability of the third parties and how it might impact on the settlement is not an illegitimate consideration or something that the court should be putting from its mind when it's considering the relevance of that being determined up front. And building on that, it is important to remember that what has happened there in this case, and taking a step back, is that Nigeria has been forced to engage in very expensive English proceedings to set aside very large arbitration awards, which this court has found were obtained by fraud and contrary to public policy. And in the context of having to set those proceedings aside, the defendant to those proceedings, P&ID, was funded extensively by the current respondents, who also put in place no provision for any adverse litigation funding. So when you're taking a step back and considering whether there's somehow a illegitimate purpose or pursuit in trying to now establish as quickly as possible the liability of the third parties for the costs, we do say that you should be viewing it in that context, and there's nothing illegitimate at all. And actually that's something that should be encouraged because of the potential impact in terms of the detailed assessment process and the possibility of it assisting a resolution of that process. Second of all, the suggestion that the substantive determination of the third-party cost application will take a huge amount of time. Of course, Nigeria has said it will take in the region of 2 days. The most that the respondents have said is that it would take 3 days. And you see that in the respondent supplementary bundle at tab 9 and page 65, which I should just show you.
You mentioned early neutral evaluation. Has there been any attempt to go back to Mr Justice Robin Knowles and ask him to do this for you? You might get a very clear answer very quickly.
There hasn't, my lord, in relation to that, in the sense that what's been said is that the stay was inappropriate and that we should be able to get on and have determined the actual question of the liability. In terms of...
But I mean, he could probably give you, if you really wanted him to, a very good idea of what the figures ought to be and whether BR Capital ought to pay it.
Well, I'm certainly not going to... My primary submission, as you know, is that the court should be finding that the grant of the stay was erroneous. But I'm certainly not going to discourage at any stage any court indicating that here there is a very strong case for the third parties being liable and ought to be paying. So
No, I didn't say that. I said he could tell you, if the parties wanted him to, what he thought the likely answer was, and you could then resolve the case. Or you could agree to be bound by his view if you wanted a proper E&E. Anyway, that's not going to happen now, so carry on.
Certainly, my lord.
I only raised it because you referred to E&E yourself.
In relation to the time estimate, you just find that if I can take you to the respondents' supplementary bundle for the appeal at tab 9, at page 65. And the bottom paragraph. On page 65, this is a letter from Jenner and Block in relation to directions. And it was said, as far as directions to a substantive hearing, if required, are concerned, we believe that a time estimate of 3 days is more realistic than the 2 days you propose. In particular, our clients will need to serve evidence responding to the multiple and detailed allegations in impropriety made against them by your client. And as a result, that is an estimate taking into account the very arguments you've heard today as to why it said this will take some time. So when you're looking at what, in fact, it would take to determine substantively the hearing, it's in the region of 2 to 3 days.
Each side is equally capable of being unrealistic in time estimates, is what you're saying.
Well, we would, of course, say that 2 days is realistic, certainly 3 days. But
given the nature of the allegations, it's very unlikely to stop short at witness statements. From what I gather, anyway, one side or the other is going to want to cross-examine someone.
I think that will be a question for direction.
It will, but I mean, it means that the case has the potential to mushroom beyond the 3 days.
But with respect to that, the issue of the liability of the first and third respondents would not take anywhere in the region of that time. So you're simply looking at how long then the allegation, because you don't need any allegation of impropriety at all.
You could deal with you could deal with them. You could have dealt with them and not bothered with Mr. Deeds. But you've chosen to lump all three of them in together, and therefore you're not going to get a bifurcation of the issues because it's all got to be dealt with in one. And so that has the potential for making it a longer hearing. That's all I'm pointing out to you, is that 3 days may be unrealistic.
But the reason I was suggesting it is realistic is because when you take into account how promptly against the first and third respondents, the majority of that time, including actually if there was any live witness evidence, there is time within that timetable for that to happen, and neither party is saying it requires more than 3 days. In relation to just dealing with the joinder and the reason why Mr. Dietz has been pursued, that's dealt with in footnote 4 of FRN Skeleton, which you find in the core bundle at tab 9, at page 66, and of course is further addressed in the 22nd witness statement of Miss Shyster Actor, which you find in tab 4 of the supplementary bundle. And the reason is that he had, we say, significant financial interest in control, and he's not in the classic position of a director in the Gochner sense you were shown, because he wasn't a director of PNID, he wasn't a director of the party who was the judgment debtor in the proceedings. He's in fact someone who, despite not being a director of PNID, seems to have been extensively issuing proceedings and, without owing duties to PNID, controlling that litigation. And we are in a situation where, as identified in footnote 4, VR Global is a Cayman Islands entity, and exactly how it holds assets and what possible arguments may be raised by it against enforcement in the Cayman Islands is currently obscure. But what you have been told by my learned friend in his own skeleton is that this is a case in which matters are often highly contested, and as a result, there is real reason to be concerned about how easily it will be to enforce against VR Global and VR Advisory, and that is, as explained in footnote 4, part of the reason why Mr Dykes, by contrast, has assets within this jurisdiction. Now, again, all of this would be solved if you had VR Global simply saying, yes, we undertake to do it, or security, and in particular the security offer. But in the absence of that, that is why Nigeria is trying to pursue to ensure it gets cost recovery and is in an informed position. Now, in relation to that, Nigeria wanting to be in an informed position, it was suggested by my learned friend that there was some inconsistency in Nigeria's position in wanting to be informed. But of course, it's important for this court to keep in mind that the application for the third-party cost orders was made on the 29th of August 2024 and amended on the 10th of October 2024 to bring in the third respondent. So Nigeria has been trying since August 2024 to establish the liability of the third parties. And of course, you've got the stay, the first stay of Nigeria's application on the application of the third-party respondents in December 2024. And we do say it was envisaged in that order that there would then be the swift progression of the proceedings after the Supreme Court had rendered its judgment, which of course it rendered in favour of Nigeria. And you see that in the order and the provision that there would be an automatic lifting of the stay after the determination by the Supreme Court of the currency appeal, and there would then be, I think it was suggested, within 7 days the parties would liaise to a list of directions hearing. I think the words might be as soon as possible, but you find that in the supplemental bundle at tab at page 132. So it can't be said against Nigeria that Nigeria has not been trying to pursue the third-party costs application expeditiously throughout. It issued it in August 2024 and would be and seeks to be assisted by the outcome of that application. Now, two other points. In relation to what you've heard today about the size of the brief fee and the guideline rates, first of all, it's important to note that on detailed assessment, the court's not going to be bound by the guideline rates, and of course there can be reason to depart from the rates where there are particular expertise required, and this is a paradigm case of a very high value, complicated set of proceedings where the rates which were charged, which were not greatly in excess of the guideline rates, should be, we say, recoverable in large parts. But the other point about that and about the brief fee is you don't find the judge at first instance dealing with any of those arguments in his judgment. So it's not that he's saying, well, I actually considered the issue about guideline rates or the brief fee, and that is why I'm saying this should be stayed. There is an absence of him doing that, and in fact, he's simply saying, well, the issue of costs remains at large, and we're saying that in those circumstances, there need to be consideration of the other arguments that Nigeria was raising as to the appropriateness of being able to proceed, and the unfairness and injustice of it being prevented from doing so. And then the final point I was going to make is that in relation to the detailed assessment process, there were various hopes by Mr Justice Knowles and indeed sentiment by this court that it would be good if there were ways to cut through that or expedite it. And of course, the position is that an experienced cost judge has been looking at the timetable, etc., and has not been suggesting that the 50-day estimate, etc., or the need for the preliminary hearing is in any way excessive, and rather, in a circumstance where a party, as PNID has done, has effectively challenged a huge number of the entries, the starting point is that those are going to have to be considered and dealt with. And so,
well, unless the experienced cost judge has it suggested to him that he might go for a sampling approach instead, which might not have occurred to him or her yet.
I'm not instructing those proceedings, so I can't comment on exactly what's been put forward or not. But it's more the case that we don't have a good reason to believe it can be done in a much shorter period of time. In relation to...
Does that mean that you can't tell us either what the nature of the preliminary issues is and whether they are potentially determinative?
I don't think they would be determinative. I think they will be of assistance, though, or maybe of assistance in the sense that they do include things like, as I understand it, hourly rates and the costs of some of the overseas proceedings, and I think also potentially things like some of the public relations costs. So I think obviously any determination of issues assists the parties in terms of progressing the resolution of the costs, etc. But it's not suggested that the outcome of that will suddenly resolve all the other issues in the detailed assessment. So,
thank you.
Unless I can assist you further, those are our submissions.
Thank you very much. Well, we will reserve judgment. We'll get it to you as soon as I can, but I won't make any promises at the moment as to when that will be. It will be sent to the people whose names have been provided to my clerk, and that will be on the usual confidential basis until such time as the judgment is handed down, and as you know, the court takes that embargo very seriously. We will hope and expect that in the light of whatever we decide, you will be able to agree an order between you to give effect to our decision. If you find that you can't, we will have short written submissions and will resolve any points of dispute without the need for any further hearing. The hand down will be electronic without the need for any attendance. I think that's everything I need to say, apart from to thank both of you and all who have supported you for your submissions in this case. That concludes the hearing.
All rise in favour.